Hi, I am Gargi Chakravarti from NLU Jodhpur. I am assistant professor there. Today I am dealing with module 15, patent law and cyberspace. This module is going to cover comparative analysis of business method and software patent of European Union, US and India. To start with that, we need to understand what is patent. Patent is one form of intellectual property right. Any inventor can get patent on invention, not the discovery. So invention needs a newness. So basic three criteria of patent granting is novelty, non-obviousness or inventive step, and commercial application. Now novelty we judge through the patent search based on the prior art. It's mean if any person is applying any patent 1st January 2014, there is a need of looking that similar type of or substantially similar type of technology already present till 31st December 2013 or not. If already present, so they lost the novelty, the patent cannot be granted. Now the next point is non-obviousness or inventive step. We judge non-obviousness or inventive step based on the similar skill of art person, any technical person expertise on the particular technical field, it is obvious for them or not. Suppose a watchmaker, the technician who is very much convenient with the tidbits of watchmaking technique, if any invention related with watch is very much obvious for any technician of watchmaking, then it is obvious in nature, nothing new in it. So for the inventive step there is a need of one step ahead. So the person in the one particular field of technology need to think one step ahead, then the inventive step or non-obviousness can be established. The last criteria is the commercial application. It is very important because whenever any company or any individual is investing their time, money for the R&D purpose, they are looking for the incentive. If there is no commercial application, so it's a wastage of time and money. So commercial application is the third criteria. Now anyone when applying for patent, the patent office not only judge these three criteria, but they also look on non-patentable subject matter. So when WTO from WTO we get the TRIPS, trade related intellectual property aspects. There are article 27 is talking about the non patentable subject matter. It is not exhaustive in nature, different country is having their own way. So our topic basically the business method patent and software patent, it is most of the country it is coming under the non-patentable subject matter. Now there is a problem of business method patent and software patent, that it is considered as a literary thing, as a language. So the point is software or business method patent are very closely related with each other. There is a very fine line difference, because whenever any business method patent is coming for the application, it is based on one software. Suppose one financial company try to protect their business method, they are having one hub and there are different customers having different mutual funds. So through one particular software they are controlling that. So it's their business method to satisfy the client. So it's a software and it's a business method as well. So they are applying for the patent. So that is why software and business method is very closely related with each other. Sometimes it's very difficult to differentiate between them. Now traditionally patent for business methods were rejected by the patent office because it was thought that computer programs, as I have said before, are more like the books, literary works. So other than the technical subject matter such as automobiles or manufacturing machines or any chemical compounds, so as such there is no product or process or functioning anything, so it is more considered like a copyright material than the patentable material. So although the patent law has been slow to adopt that particular thing, but the point is the copyright and patent difference is that copyright is for a very long time. We know that according to the Berne Convention it is author's life plus 50. If from the company point of view it is 50 years. Now in India it is author's life plus 60. In case of US and European Union is author's life plus 70. So the shelf life of the software is very less. Shelf life of the even software related with the business method is also very less. So what's the point of having such a big long time for the protection? So it is not really acceptable by various companies. And not only that, copyright is having an inherent problem that idea is not protected under copyright, only the expression. So on the basis of the same idea, when different expression is coming, so different expression is having the protection. But in case of patent, idea itself is patented. So the strictness or the rigidity of the protection or monopoly based on that is much more higher than the copyright. So the it's a very slow process, but now companies are really looking for software and business method patent than copyright. Although patent law has been slow to adopt, the law has been rapid advances in the recently. Different countries and their regional office have different standard for granting patents, as I have said earlier, particularly for the computer implemented invention, because non-patentable subject matter is covering the mathematical formula, some basic scientific principle and algorithm, and software and business methods good lot of coming under this particular purview. So it's a very difficult situation to give the patent on that. Now if you go by the history of business method patent, patent protection for business methods is very new in the time frame. According to the technological advancements, this desirenousness is increasing day by day. So recently different country is trying to get patent on the software and business method patent. In the year 1998, if we go by one decision from Court of Appeal of the Federal Circuit in the case of State Street Bank and Trust Company versus Signature Financial Corporation, this particular case altered the situation dramatically. The verdict supports a patent on software program that was used to make mutual fund asset allocation calculation. In the view of that particular decision, companies started looking for and obtaining the business method patent. USPTO reports that in 1998, near about 1300 patent applications related to business method patents applied, but among them only 420 such patents were issued. I have already discussed the problem related with granting the business method and software patent, because it is related with mathematical formula, it is related with algorithm. So it is related with just like a language or just like a program. So technicalities, proving the technicalities, proving the functionality, proving the machine related aspects is very difficult. So that is why quite low in number. But if we move forward in the year 2000, we find it out that near about 7,500 applications for business method patents were filed and 1,000 such patents were issued. So we can see that with the advancement of technology, it is increasing day by day, and desiredness of companies also increasing. So there is a pressure on the USPTO in the policy implementation in the government to have patent instead of having copyright in it, which is already prevalent in the software field. The European Patent Office from South Africa, Japan, India are also currently concentrating to issue the business method patent, though they are till now doubtful, and it is under the debate and discussion for the granting of patent on business method and software. Now, we need to understand what is business method. It is extremely difficult job. Nowhere it is defined which is called business method. Now, the term business method has a very large economic perspective, as it comprised of various economic activities. Those various economic activities can be related with sale and purchase of the items, marketing of different items, financial methods, schemes and techniques of doing this particular marketing. Though it is known as a bad patent, recently one patent granted in US, it is simply based on a clinic how to handle their clients. I mean, the person used to call the clinic for doctor's appointment, and if the appointment is available, they registered that name, or according to the availability they advise or suggest the next day. So in this way they just to maintain the client call and client appointment. It's through a software they used to do that. It is considered as a business method. It is applied in the USPTO and it is granted. But the point is, where is the huge amount of technicalities are related with it? It's nothing but a inherent algorithm is just running that particular process. This is not the process even. No mechanical function is coming out of that. So it's a huge debate and discussion of granting that type of patent. But it is difficult to find a proper legal definition for the business method also. We need to accept that. Hardly any country having that particular definition. Now, EPO once tried to give one definition. They have suggested that business method is concerned more with interpersonal, societal and financial relationship than with the staff of engineering. Thus, for example, valuation of assets, advertising, teaching, choosing among candidates from a job, etc. can be considered as a definition of business method. But when it is suggested and released, it was just rejected by all of other people and the panel. It cannot be a definition of the business method. So US also tried to attempt to define the business method. US made an attempt to define business method in the year 2000 by two congressmen. First one, a method of administering, managing or otherwise operating an enterprise or organization, including a technique used in doing or conducting business. Then processing financial data, any techniques used in athletics, instructions or personal skill, any computer assisted implementation of a method described in paragraph 1 or a technique described in paragraph 2. Now, the USPTO defines this business method very narrowly as a patent classified in US patent class 705 is very close to this particular definition, that data processing, financial business practice, management or cost or price determination. So, here you can see what I have said earlier, business method and software is very close to each other, because the business method they want to protect under patent, it's nothing but a software running something. Software, I mean, independently can be patented. It's a different issue. But even the business method they are asking for a patent, it is actually software run one methodology to run any business. Now, as I have said, one European Union definition was rejected earlier. They tried again, and according to the European Patent Office, they try to formulate one business method and they include one particular term, technical effects. It's a very ambiguous because the technical effects, that particular two words, is nowhere clarified properly. Now we need to base on different cases to understand what exactly they try to mean by the word technical effects. Now if any software is having the technical effects, it can be granted as patent, otherwise not. Situation is different in different case of business method patent. Now article 52 clearly rejects that business method from patentable subject matter by excluding schemes, rules, methods for performing mental acts, playing games or doing business and programs for computers. So straight ahead, European Union is rejecting business method patent and software patent from the list of through the list of the non-patentable subject matter. However, according to Article 52 3 of the EPC, the provisions of paragraph 2 only exclude invention from patentability to the extent to which a European patent application or European patent relates to such subject matter or activities as such. Now, what is the meaning of as such? Again, creates a huge problematic area. There is no clarification of that particular word as such. Now, this complicating situation creates more problem for the patentability of the business method patent and software patent. It should be come under the patentable subject matter or it should be counted straight ahead non-patentable matter. So there is no need of examine that. So they can reject any whatever may be the business method and software patent is coming their way. Now European Union proposed to consider software and computer program as patentable invention and also pursued to grant a patent on an algorithm or business method. So the debate or dilemma start from here. Currently EPO grants patent for invention in many fields of technology in which computer program makes a technical contribution. So here again that word through the software or through the business method or the computer program is at the end result giving some technical contribution. So technicality should be related with that, not only the running anything. Such fields include medical devices, any automotive sector, aerospace, industrial control, communication, media technology such as automated natural language translation, voice recognition or video compression or also the computer processor. If any software is giving the technical effects, means the technical contribution is there and giving such functions, then it is allowed for the patentability. Now we need to go through some case studies, then we can understand on what ground it is granted and on what ground it is not granted. One landmark case is Wacom case. It's a principle deriving case. We can get guideline for patent granting through this case. The invention was related with the method and apparatus for improving the quality and speed of digital image processing. To get the technical result in this invention, algorithm has been used and hence the question again arises that mathematical algorithm implemented in this particular method by the technical means. So technical board of Apple considered these effects as technical effects and held this invention within the scope of patentability. So though here the mathematical algorithm is used, but the methods are used by the technical means and there is considerable technical effects also there, so it can be considered as patent. The following guideline has been emerged from that particular judgment. An invention which is technical in nature can be considered as patentable. Mathematical algorithm can be patentable subject to condition that it is incorporated within a technical process. any process giving technical result is a technical process. Technical result will come where there is a change in a physical entity. So, I am starting with a process. Through this technical process, from one function I am getting something other. So, there is a substantial change by this technical process. So, there is certain result. So, it is patentable. That is the guideline from the Viacom case. Now, come to the Koch and Sturgill case. In this case, invention was related to a computer related X-ray apparatus. In this particular case, the board affirmed that Viacom guideline. It also ascertained that if an invention is a combination of technical and non-technical components, so non-technical components should not overpower the technical components. So, if the technical components is substantial, then there is no problem of granting patent, and of course, the Viacom guideline is applicable here, as we have said earlier. The technical results, technical effects, the function and substantial technical changes, all those things should be considered here. Now, Merrill-Link application case and Gell's application case. The invention, Merrill-Link invention was computerized system of trading in securities, where court held that though the computer program as such would not be patentable, but technical effects of the program can be patented. In Gell's application case, the court did not found any technical effect in the invention, hence they considered it is non-patentable subject matter. The invention is a part of a process which is to be used in providing a technical result. Court found that technical effects is not there. So, here as we have said, the technical result and technical effects is much necessary to establish to granting the patent. Now, there is no as such guideline what can be considered as a result, what can be considered as a the substantial contribution and changes, but according to the different court cases and granting patent scenario, we can get that what can be considered as a patent. Only based on mathematical formula or algorithm, when there is no technicalities, I mean there is no technical changes as such, the reproduction is not as such, then it is not possible to get a patent. Now, Koschuk versus Benson case, it is one of the early cases regarding the computer software patent. In 1972, this case was decided by Supreme Court. That difficulty in deciding whether conversion of binary coded decimal number into binary numbers by using just an algorithm could be considered as patentable, where finally Supreme Court decided that said algorithm is not patentable, because most of the countries the algorithm and mathematical formula is non-patentable. We need to understand one thing, because patent is nothing but a monopoly for 20 years and this software field is ever growing fields. It is, the growth is enormous, each and every day there is a growth. So, if we monopoly the situation in such a manner that other technicians, software developers, software engineers, they do not have the scope to go further based on the previous one. So, there is a very shrinking condition. So, there will be a closed door for the further development. So, for that reason, the very basic algorithm and mathematical formula is excluded. It is not like that patent granting is problematic on that, but patent granting is problematic for what reason we need to understand first. So, this is the reason behind this. For the growth, there is a need of less monopoly in that particular field, so technicians can go further based on that. Of course, there are certain exceptions and limitations are there for the research, for the academic purpose, they are free to utilize these things. But For the commercial purpose also, that sometimes there is a need of reverse engineering, there is a need of further innovation. So some flexibility is needed. In the very rigid condition, it will be very difficult situation for the technological advancement. Now the next case, Parker versus Fluke. In the particular case, business method had come into question. The Supreme Court ascertained the patentability of the method of updating the alarm limit used to signal abnormal condition in a catalytic process. The said invention was found non-patentable based on the prior art. First, I have said the three criteria of patentability. One is the novelty. So we are always establishing the novelty based on the prior art. So on the application date, before that date, we need to be sure that there should not be a substantially similar type of already technology is there. So here, according to the prior art, it was rejected. Though it was found that the algorithm was not only calculating the new alarm limit, but also additional step is included beyond the mere calculation step. Now the landmark case is Diamond versus Deal. In this historical decision, the position quite changed by the Supreme Court. US Supreme Court decided that USPTO to grant a patent for an invention related to a computer software, related to a method for determination of how rubber should be heated in order to be best cured. Computer software was used in this invention to estimate and regulate the heating time for the rubber. Actually, they are putting the melted rubber in the mold. So this software is actually estimating or regulating the heating time for that melted rubber. This invention was included the additional steps in relation to heating and removing the rubber in the process. Because of this additional function, this invention was held as not a mere mathematical algorithm. So good lot of functionalities are related with that, not only the algorithm, computer program for a method, but the process for molding rubber. Thus it was found patentable. So there are a good lot of technical effects. Here there is a good lot of technical results and good lot of changes are there due to technicalities. So the patent is allowed here. The issue need to be considered for the business method patent is whether the invention is technological. If not, then it will not be patentable in spite of meeting the other criteria of the patentability. Now the next case is the State Street Bank and Trust versus Signature Financial Group. In 1998, in this particular case, Federal Circuit Court had clarified further the issue of business method patentability. Signature Financial Group had taken a patent on their method of running mutual funds. So there is a hub and there are certain spokes. So several mutual funds are just a spoke and they pull their investment, and one single portfolio, that is called a hub, they are maintaining all the customers' mutual funds running by a software. So the software determines actually the value of each fund based on percentage ownership of each of the assets in the hub portfolio. This information is stressed on day-to-day basis and is used to track fund share pricing and tax accountability as well. Federal Circuit held the patent valid and explained that as this method provided a very useful, concrete and tangible result, it had to be considered a patentable subject matter. After this decision, business method become a patentable subject matter, but subject to ensure that the method is operated upon by a computer process or stored in a computer readable media. This requirement is not difficult to meet if the patent claim is drafted very carefully. Here another question is how the claim, because to get a patent, there is a need of patent specification. So, patent specification is having the title of the patent and a brief description, the abstract of the technology, and then the details of the technology, and lastly on what the patent is usually granted, that is the patent claim. So, the claim portion needed to be drafted very carefully, so it can show how that particular that computer program is giving the technical effects, technical result, there is a substantial change through that technicalities. Then the patent application can be granted. In this particular field, one landmark case is the Bilski case. In the Bilski case, it was further clarified as the patent examiner rejected though this particular patent, Bilski patent, but they have clarified it that patent claims based on the reason that it is not implemented on a specific apparatus, only solving a purely mathematical problem without any practical application. So, here it is just an algorithm, just a mathematical formula, there is no substantial technical effects related with that. So, it cannot be, patent cannot be granted. Board of Patent Apples and Interfaces and Federal Court have reaffirmed the rejection, and their explanation had given more understanding about the patentability of the business method. So, here they have used a particular phrase related with business method or software patent, that it should be useful, concrete and tangible result. So, there should be certain result, certain technical changes related with that. And for Federal Circuit Court, the invention was not transforming any article to a different state or thing. So, thus it is non-patentable according to the section 101 of US Patent Act. Now, there is a need of comparison between the US and European approach. US approach is quite pro to software patentability, Europe towards non-patentability for software and business method patent, at least from the legislative and judicial level. It is easier to get that patent on business method invention in US. It is easier to meet their criteria even when it is useful, concrete and tangible than European criteria of technical effects, though technical effects is not clarified properly or not defined properly, but meeting the criteria of technical effects is quite difficult in European Union than US. Business method that controls a machine would meet the European criteria of technical effects, and that will also qualify for patent in US, as it would also meet the American criteria of useful, concrete and tangible result. But purely business method involved with economic dealings and practice would not be patentable in Europe, though they might meet the American criteria, and it can be patentable in US. A business method which is used for a computer software in many new internet business models, it's very well known now, will be patentable in European Union, not patentable in European Union, but patentable in US if it has the required technical contribution. Though the getting patent for this kind of invention also not so easier, but in comparison we can say it is easier in US and it is not so easier in European Union. Now we need to come back to the Indian approach. India does not allow the patent on business method and software. TRIPS Article 27.1 does not mandate the extension of patentability to software and business method. Nowhere it is written. As I have said, it is not really exhaustive in nature. Nowhere the field of technology is mentioned. So, we have section 3K, actually Indian Patent Act 1970 is having section 3, and section 3A to P is having all the non-patentable subject matter. We know that for the patent application, first they look through the it is coming under the non-patentable subject matter or not. If it is coming under the non-patentable subject matter, then patent office primarily reject that thing, then they go for the further investigation the novelty is there or not, inventive step is there or not, commercial application is there or not. So here in this case of business method and software under section 3K in India, it is not patentable. So a mathematical or business method or computer program per se or algorithm is non patentable in India. Regarding business method and software patents, following clauses is introduced in Patent Amendment Act 2002. New clauses like that: a computer program per se, other than its technical application to industry or a combination with hardware. So here the word is software per se is not patentable. Now per se is not defined anywhere. We need to understand what is the meaning of the per se. So this is the meaning when it is related with any hardware or the application is giving certain or related with any industry. Not mere algorithm cannot be a patentable thing. So it specifically declared that the mathematical or business method or a computer program or algorithm is not being an invention within the meaning of the Patent Statute of India. The Patent Office considers a particular method to be a business method if it involves a monetary transaction or mere marketing or sale purchasing methodology. Now section 2J, as amended by the Amending Act of 2002, defines an invention as a meaning a new product or process involving an inventive step and capable of industrial application. Even section 2 subsection JA also inserted by that amendment defines an inventive step as meaning a feature of an invention that involves technical advances as compared to the existing knowledge or having economic significance or both, and that makes the invention not obvious to a person skilled in the art. The government tried to extend broader protection to software invention. The Patent Amendment Ordinance 2004 was circulated in December 2004, and section 3K was amended to exclude from patentability a computer program per se other than its technical application to industry or combinations with hardware. So there is a need to prove the invention, a substantial contribution, long unsolved problem, cost effectiveness and good amount technical effects. But as such, business method and software per se is not patentable in India. The Patent Amendment Act 2005 revoked the ordinance and restored the earlier position. So still we are having that particular notion, software per se and business method, mathematical formula is not patentable. On March 23, 2005, the Indian Parliament declared the third post-TRIPS amendment to its patent statute. This Patent Amendment Act 2005 had created some possibility of amendment to create some kind of window for business method patents, possibly just algorithm or methods having technical application. So there is a bit hope for who is desiring having patents or having patents on software or business method. Now mere algorithm or mere just business process cannot get, but when it is having a technical applications, then it can be considered as a patent. Recently the Indian Patent Office has published a new draft manual of patent practice and procedure in the year 2008 relating to the patent practice to be followed by the Indian Patent Office. After its publication, the government invited comments from interested parties including legal practitioners and industry, arranged stakeholders meetings across the country to get their suggestions based on that, because information technology, computer related thing, the particular market is growing day by day. India is a very prominent country on that particular technical field, very well acclaimed throughout the whole world. This meeting generated strong debate with the opposition of the guidelines set out in the manual. patent software would inevitably create a restriction for which upcoming software developer might needs to obtain clearance from predecessor developer to begin his work on it. India as a developing country, as a developing field of technology related with software is or computer program need some open space to work on that. Patent creates a monopoly. So whenever this particular monopoly is having any predecessor, there is a need of license, there is a need of consent. So clumsy situation can arise which can create a good hindrance for further proceedings. But acquiring this clearance are costly. So with that, if there is any infringement of patent, then cost can be much more higher. Litigation can increase the cost of that particular small company, that particular individual. So situation can be much more worse. So unfortunately, patent search is very slow process. Now till publication there is a there is a need of secrecy. So within that time, if any developer is similar type of software is developing, there is a good potentiality of violating that. And in this particular field, it is a trend that based on some invention, further innovation is going on. But prior art can kill the novelty, inventive step is missing. So the criteria of patent is not having, so patent granting is problematic, and as well as if anyone granting the patent, then patent infringement is quite high. Then the whole scenario is very important. Survival issue for the smaller competitors in the market. Indian Patent Office is quite incapable to evaluate complicated and technically trivial claims. It's not like that, but it is actually shrinking the space for the further development. It is important to note that to grant software patents or to tackle patent infringement, India need a huge investment for expert personnel, well-equipped maintenance of certain quality standard. On the other hand, there is a need of investment to utilize the new software development which can be beneficial for the software industry, and economic growth also needed for the country in general. Now we already have discussed the pros and cons of the business method patent and comparative analysis, European Union, US and India, the approach towards granting the business method patent, and what is actually hindering to give the what is the hindrance, why people are quite restrictive to having the business method patent. India is not at all open to that. European Union is not at all we can't say, but very restrictive way they are behaving. US is quite pro to that. So there is a need of economic analysis now. Now the thing is like that, two things are there. One, in one hand, incentive is needed. Patent create monopoly, correct, but on the other hand, it is giving the incentive to the developer. It is giving the incentive from the market that can enhance the research and development, and in other hand, it can, that monopoly can create a very restrictive mode which can shrink the further applicability of previous the previous patent, which can be hindrance for the access and affordability and availability also. So this is a debatable and very debatable topic. Throughout the whole world it is going on. So we are looking forward for that. We have already neutrally discussed the pros and cons about the business method and software patent. So we need to and it is also based on a very personal input in from what angle we are seeing this, it is allowable or not allowable. Here I am finishing my presentation. So this is as a whole the patent and cyberspace.